Hi, thank you so much for inviting me. When I was originally invited, I tried to make sure that there was all sorts of caveats in place, especially that I'm not an expert in socialist municipal theory. I don't come to you as a city developer. I don't come to you with a background in architecture or planning or anything of the sort. I stand here today simply as a lawyer who has spent quite a lot of my time in parks and alleys looking for my clients. And the reason I have to do that is because of austerity measures taken by governments that have forced people to the streets. And so I won't be offering you the most academic of views, but rather my reflections based on the work that we've been doing for the past 2 years. Austerity touches a great many facets of our lives and a great many facets of governance. But where I see the rubber hitting the road most seriously is when it comes to housing. Because that's where we see some of the most egregious human rights outcomes for people who are marginalized in their housing or have no housing at all. And so that's where the focus of my work has been. And a lot of the harm that we see is based on a fundamental fallacy. And that fallacy that is touted by government at the municipal, at the provincial, and at the federal level is that the housing in Canada is a market. It is driven by market forces solely, and it should be left to the market. And they are incorrect in this. We live in a housing system. It is a system in which government has intervened to a much greater extent in the past and has the capacity to intervene in the future, and in fact has a constitutional obligation to intervene in to protect people's rights to safety, health, security of the person, and their right to protect their own lives. And so, as Ivan mentioned earlier, we need to challenge the notion, these impossibilities that get set up. And one of the impossibilities that we need to challenge is the notion that you can't do anything about housing because that's up to the market. That is an impossibility created by governance and an impossibility that we can actually fix simply by changing discourse. And so I'd like to just review a couple of areas where theories of austerity have driven policies and laws, and how those policies and laws then further drive austerity measures. It's actually sort of a self-feeding feedback system of policy, myth, and law that continues to feed itself. For example, I'll start with anti-camping bylaws. So, as many of you probably know, we've spent the better part of 2 years in litigation against the city of Abbotsford for bylaws that prohibit people from setting up a basic survival shelter in any public place in the entire city, from being in a park overnight, and even from camping in your car if you don't have somewhere else to live. These bylaws are based on a perceived need to control public space. And one of the first things to remember is that in a system where governments view parks and public spaces as being, and to go back to a BC politician, for those who pay for them, then you end up with a series of laws that assume that those who don't have housing are also illegitimate users of public space. And so bylaws that criminalize necessities of life become more prevalent. The types of bylaws that we saw in Abbotsford exist in almost every city across this country. And the types of enforcement we see are not unique to Abbotsford. Tent slashing, by law enforcement, pepper spraying, chicken manure, displacement day to day happens across this country. It is based in a myth that people living without housing do not have a right to public space, they are not equal citizens, and that they should not be given housing because housing should be left up to the market. And that is one of the most devastating theories of austerity that we live in today, and I believe it's fundamentally wrong. One of the fundamental things that we see come up when people fight to defend bylaws of this nature is theories of choice. We live in a country right now where the federal government, as you all know, gave up on housing almost completely in the mid-90s and have done very little to build social housing ever since. Instead of realizing that that obviously led to people being pushed into the streets, governments now espouse choice as being the reason why they don't need to protect people. People are choosing to be homeless. It's easier, they're lazy, they should probably get a job, they could go to the shelter even if the shelter is full. The litigation that we undertook was partially driven by the need to challenge that notion of choice, and we were successful on that. The results by the court found that obviously shelter is a necessity. You need more than a blanket. Displacement itself causes harm. And that's really important. Not just displacement from your community, displacement out of Vancouver, but being displaced on a day-to-day basis and told to move along causes harm to your health and serious psychological harm. They found that the enforcement tactics were things that absolutely must be condemned and that we should expect better from our government. They also found that the theory of choice as being a reason not to protect people and not to provide housing is fundamentally flawed. We see these types of, as I said, these types of laws, I believe, are based in a misunderstanding of how governments have created state-sponsored poverty. And we see this same type of theory come up in a series of other municipal bylaws, such as anti-panhandling bylaws that exist in many municipalities, or what in Vancouver gets called aggressive panhandling bylaws. Across the United States, you see them in anti-sit-lie bylaws, where you're not allowed to sit or lie down anywhere in a public place. These, of course, only get enforced if you happen to look like maybe you don't have somewhere else to go. We see them in anti-vending bylaws. Vancouver has a bustling economy of vendors on Hastings Street and other places in the city, where people sell things like food they get from the food bank or things that they found in the garbage, and they do that to survive, to get enough money to get through the day. The city of Vancouver has recognized that that is a survival economy, but nonetheless criminalizes it when it happens on the streets and sidewalks of our city. So, going back to Abbotsford for a minute and thinking about what does all of this mean for cities. So the bylaws in Abbotsford were found to be unconstitutional because they prohibit people from setting up basic shelter and from sleeping overnight. Those same findings are equally applicable to every city in this province. And I can assure you that other cities are taking a close look at their bylaws, and they need to be. Because even if this was about a set of circumstances in Abbotsford, the same laws exist and the same need exists across the province. The court found that there's a need to shelter during the day, that displacement is harmful, and made a very, very important finding for people who want to advocate for change in how governments operate. The court found that in order to govern in a more minimally impairing and balanced way, which is legalese for constitutional and okay, that space needs to exist where the homeless can shelter, sleep, rest, stay warm, wash, eat, and attend to personal hygiene. It's a very significant finding. Courts are notoriously conservative, and they won't tell a government how to do their job. But what they can do is set constitutional minimum standards. And that statement means that if this government, if Abbotsford and any municipal government, wants to govern in accordance with the Canadian Constitution, space needs to exist for those people where they can do all of those things. Now it's over to governments to make a choice. A hands-off approach to government would simply be to say, fine, we'll let people sleep in parks and do what they need to do to save their own lives. That is neither good policy from a health perspective, from a human rights perspective, or from an economic perspective. On the other hand, progressive governments can take this as an opportunity to make sure that there is housing, that there are washrooms, that there is running water for people who don't have somewhere else to go, because that is safer, it's less expensive, and the alternatives, as we've seen across the province, have led to human rights abuses, early death in the streets. People who live in the streets are far more likely to die at almost half the age as the rest of the population. And the other alternative that cities have moved towards, and which I would say are still based in the myth of choice and a failure to really grapple with the place that municipalities can hold in terms of progressive government, is looking towards shelters. Emergency shelters are, again, not good policy. They are extremely expensive. They are not accessible by the most marginalized among us because people are turned away from them if they display symptoms consistent with mental illness. People with addictions, people with histories of trauma are often turned away from shelters. Women and trans people are often not safe in shelters, and shelters, frankly, are not housing. They perpetuate displacement on a daily basis, and they're extremely expensive. This litigation, both inside and outside of Abbotsford, has led to municipalities hiring outreach workers, hiring people to consult on policies to actually provide housing and end homelessness. They have led multiple municipalities to look at reconsidering their bylaws and possibly re-legislating. They've led at least 2 municipalities to opening new shelters and to cities looking towards more low-barrier housing as opposed to high-barrier housing, which many municipalities, especially outside of Vancouver, rely on. And so what we've seen so far is that litigation can be a catalyst towards change, but only when there's progressive movements behind it, providing the policy to move forward. Litigation can only go so far, and then it's up to the progressive minds in this room to help governments understand how to move forward. I'll very briefly touch on a couple of other areas where austerity and law enforcement and law creation intersect in a way that we find harmful. For example, if you look at Vancouver Standards of Maintenance Bylaw. Standards of maintenance bylaws are touted as being a really effective way of protecting low-income housing, but they're a downstream, very last-minute emergency stopgap measure. Vancouver has a standards of maintenance bylaw. It very rarely gets enforced, and when it does, it's because things have gotten so bad that it is an absolute dire health and life emergency in those housing units. It has only been enforced a couple of times in the downtown SROs, and only in circumstances where it really is too late. For example, many of you may be familiar right now with the Lion Hotel on Powell Street. The city is seeking an order against the owner of the Lion Hotel to put heating and hot water back in the hotel. It's November. They haven't had heat or hot water since approximately Remembrance Day. However, the way that the bylaw is formulated is, again, based in this notion that A, the market will fix it, and B, cities don't want to intervene too much. They're now giving the owner 60 days. 60 days to get the heat fixed before the city can move in to fix it. That means that these people in this hotel who are paying rent and who are paying disproportionately more for their rent for a tiny, tiny room than probably anybody in this room here today will go through the holiday season and the month of January during a cold snap with no heat, potentially. The city could legislate to give themselves emergency powers to go in and fix it now and charge the owner, but instead they legislated that they have to give the owner 60 days. So not only is that bylaw frankly ineffective at saving those people's lives and health right now, it is, as you see, such a downstream last minute, last resort type of law that it is too heavily based in the notion that cities shouldn't intervene sooner. This type of reactive policy rather stops cities from taking more progressive approaches, such as purchasing the private SROs so that they can actually manage them progressively and before things get to this point, before people don't have heat and hot water. And they stop cities from actively levying conversion and development fees in such a way that would actually both fund social housing and also act as a deterrent for some of the gentrification that we see in the neighborhood. And in the end, not only is this type of bylaw enforcement and sort of neglect of low-income housing, not only is it a risk to health, life, and safety, it's also expensive. So if you look at the risks of it, you see that people are going to find a way to keep themselves warm. That means there's a fire risk in that building right now. Someone's going to get a lung infection. That means that healthcare costs are going to go up for everyone. And some people are going to realize that in the short term, they might actually be better off in a shelter because at least they're heated. That means that if someone comes from the Lion to an emergency shelter because they'd like to warm up tonight, even though they're paying rent, that's another person that will find themselves on the street because the shelters are full. And so it perpetuates a system that is not only expensive but harmful. And finally, I'll talk very briefly about theories of social mix. Again, not an expert here. So if you would like to, I would commend you to so many of the experts on neighborhoods and social mix to do further research. I can only speak from my own experience and what we've seen. Their social mix theory is something that is relied upon heavily by cities, and part of the reason is because they say we simply can't afford social housing. We can't afford to house people, we can't afford to provide what people actually need for the necessities of life: water, heat, shelter, food, some place to access personal hygiene and go to the bathroom. Unfortunately, what we see is when, at least in the downtown east side, when there's too much focus on social mix theory, which is based on the notion that if you bring rich people into a neighborhood, it will make that neighborhood healthier. Yeah. What we actually see, though, is that that also brings in higher-priced restaurants. It pushes out the people who don't, quote-unquote, pass. Social mix housing means that my clients, people who may not display behaviors that someone who is wealthy is used to, will be pushed out of their housing. They'll be pushed into the shelters, and then as neighborhoods develop, there becomes pressure to close those shelters, and then people get pushed off the land that they've relied upon, sometimes for generations. And so the reality of relying on social mix rather than cities taking a progressive approach and looking at shelter that is actually provided at a rate that is affordable for people living in poverty, and providing opportunities to actually move away from poverty management and into progressive forms of governance. We see increases in displacement, we see increases in homelessness, harm to the most vulnerable people, and increases in things like health costs and policing. And policing is never the answer, ever the answer to legislated poverty, which is the sort of current state of affairs that we live in. And at the municipal level, some of the things that perpetuate this type of development, which again perpetuates displacement, are local area plans that don't acknowledge the need to maintain simply low-income housing. Because if you replace all of the housing in a low-income neighborhood with mixed housing, the net effect will always be displacement of those low-income people, because you're going to lose more low-income housing units than you eventually gain through social mix. It increases, this type of thing is perpetuated by bylaws, development bylaws and zoning bylaws that don't require affordable housing and allow for developers too much leeway to say that they are developing affordable housing, but in fact developing condominiums and other developments that actually cause displacement and conversion of low-income housing in the surrounding neighborhood. And they're also perpetuated by housing agreements. The City of Vancouver enters into housing agreements with developers and landowners, which are designed to create affordability, but which do actually do very little for housing and affordability, while also increasing development and gentrification. And finally, this type of displacement then perpetuates, again, the higher cost, because you need increased infrastructure. Because you end up with a labor force, like Ivan said, you end up with so many people in Vancouver working in low-income work who can't afford to live in the city, who then need to live outside the city, travel into the city. So now you need increased infrastructure, you need increased transit, and you have a decreased access to workforce. And that actually ends up leaving the city dry of what you absolutely need to survive. And so those are some of the ways in which we see, anyway, that bylaws primarily drive aspects of poverty and stop cities from taking proactive approaches to governance. And I'll just conclude by saying, as a lawyer, I understand that much of municipal policy is based on risk management and litigation risk. I admit, very long time ago, very briefly, I worked for government. And so I know that what your job is most of the time is to mitigate risk and to stop the government from getting sued. But if you look at this, and if you actually question, when governments come back to you and say, we can't do this because our litigation department said there's too much risk that we would be sued, or that our law wouldn't uphold challenge, just remember that that is done purely from a pragmatic perspective. And that means the only risk they are assessing is the risk that a rich person with access to lawyers and access to the court system will sue them. They are not taking into consideration the risk that they are fundamentally breaching the constitutional rights of marginalized people. And the only reason they're not taking that into consideration is because of how difficult it is for marginalized people to access the courts and to access justice. And so when you hear those opinions, we can't do it because of the litigation risk, question that heavily. It is based in a myth, and it is based on the hope and promise that marginalized people will not find their ways to the court system, and the more we can help those people access justice, the more it actually changes the way that governments consider risk and litigation risk. And very finally, just in response, Gary mentioned something really interesting about municipal jurisdiction. He mentioned municipalities control a myriad of things, including housing. And I would simply say again, please challenge when your cities tell you they don't have jurisdiction over housing. Yes, we live in a federal state, and the province has primary control over housing. That does not mean that cities can't act. It simply means that, according to the Constitution, that falls to the province. So question that. It doesn't mean cities can't act, it just simply means that they aren't. Thank you.